Hello, excuse me. Hello to all of you who are promptly on with us. We are going to wait just a few minutes, only 2 or 3 minutes, just to get people to enter the Zoom before we start the webinar. But I just wanted to welcome all of you and acknowledge that we have started. Okay, welcome to those of you who are signing on. You can see that another 15 or 16 have signed on in the last minute. We're just going to wait a couple of minutes to let more people sign in to the Zoom before we get started, but we're not going to delay very long. Welcome to those of you who have joined in the last minute. We're just waiting a couple more minutes to let people sign on before we get started.
Judge, you know, I might mention too, for those that have signed on, that if you have colleagues or staff that are unable to attend the live webinar, that this webinar is going to be recorded. It's currently being recorded and will be available on the NAPCO website with any materials that the panelists refer to, so that you can access not only the program, but you can access some of the documents, and we will also have the biographies of the panelists in case you'd want to reach out to them.
Okay, maybe one more minute max, and then we'll get started. Okay, so welcome to all of you who have joined. I assume that people will continue to join as we get going. Some people are probably delayed in court and so forth, and so I expect that number to go up. So let me introduce myself first. My name is Roxanne Balin. I'm a retired judge in Boulder, Colorado. I served 31 years on the bench. In the last 15 years of that time was as chief judge, because unlike many other states, our chief justice appoints chief judges, and we serve for as long as we want to, and as long as the chief justice is still happy with our performance. And I loved my job so much that I stayed for 15 years. Before I became a judge, I was a law professor at the University of Colorado School of Law. And I currently work as a part-time consultant with the National Center for State Courts in areas of leadership and governance, court efficiency, case flow management in criminal, civil, family, and specialty courts, and also done some work with court facilities. I also consult with our Colorado State Court Administrator's Office on drug courts and provide motivational interviewing training for judges on a national level. I want to introduce you to our panelists. First is the Honorable Judge Barnett. He is the Chief Judge of the Minnesota's 4th Judicial District in Hennepin County, which is Greater Minneapolis. It's a unified trial court handling all kinds of cases. He became Chief Judge on July 1, 2020, having been selected by a vote of his colleagues for a 2-year term. However, he's just been confirmed for his 2nd term, and so will be serving for 4 years. It's the largest county in Minnesota with 61 judges. The district has 1.27 million residents. Judge Barnett also served as the Assistant Chief Judge and Presiding Judge of the Criminal Department before he became Chief Judge. He's been a trial judge for 14 years, covering all of the varieties of cases. He was appointed initially in February of 2006. Prior to his appointment to the bench, Judge Barnett was a senior attorney with the Office of the Hennepin County Attorney and a deputy public defender with Hennepin County Public Defender's Office. Next is Judge Welty. Judge Welty is the presiding judge of the Arizona Judicial Branch in Maricopa County, which is Greater Phoenix, having been appointed to that position for a 3-year term by the State Supreme Court in 2019. Presiding judges in Arizona can succeed themselves for a successive 3-year term, which is happening in Judge Welty's case, so he will have a second 3-year term. Maricopa County is the 4th most populous county in America, with an estimated population of 4.7 million people. And before becoming presiding judge, he was assistant presiding judge. He was appointed to the bench in 2007. Before becoming a judge, Judge Welty worked for 16 years as an assistant U.S. attorney with the United States Attorney's Office for the District of Arizona. And he also served as an adjunct professor at ASU and taught extensively on a broad range of topics for the U.S. Department of Justice and the State Bar of Arizona. And he has also served on a number of statewide committees. Next is Raymond Billett. He is the administrator for the Judicial Branch of Arizona in Maricopa County, serving as the senior executive officer for this very, very large county. Previously, he held positions in Pennsylvania in the Judicial Branch as a district court administrator for the 5th Judicial District, Allegheny County, which is Greater Pittsburgh, and also in the 46th Judicial District of Pennsylvania in Clearfield County, which is the Greater Clearfield area. He holds a master's degree in public management from Carnegie Mellon and is a 1991 graduate fellow of the Institute for Court Management, Court Executive Development Program. During his tenure with the courts, he has led numerous successful court improvement projects, including case flow management revisions, jury reform, strategic planning, jail reduction strategies, and the use of evidence-based practices in both pretrial and post-adjudicative phases of the criminal justice system. Next is Patricia Tobias. She is a principal court management consultant with the National Center for State Courts Consulting Services Division. She has been with the center since August of 2014. She has extensive experience working in a wide variety of national, statewide, and local projects, including those involving leadership and governance, case flow management, strategic planning, etc. Prior to her position with the National Center, she served as the administrative director of the Idaho courts for more than 20 years, beginning in November of 1993. And then also on your screen is Gordon Briller, who is currently serving as the executive director of the National Association for Presiding Judges and Court Executive Officers, NAPCO, which is a nonprofit public benefit corporation composed of state and local trial court leadership judges, leadership teams, and court executives. He also works often with me, part-time with the National Center for the State Courts Court Consulting Services, having retired in January of 2020 as a principal court management consultant after 14 years. Previously, he was the administrator of the trial courts for the judicial branch of Arizona in Maricopa County, the court administrator for the Superior Court in Maricopa County, the judicial district administrator of the Second Judicial District of Minnesota, and court administrator of the municipal court in Hennepin County, Minnesota. So, a very illustrious and distinguished group of panelists who I'm sure will have some very interesting answers to the questions that I'm going to be posing later. I wanted to start though by kind of setting the stage. Just a moment. Setting the stage for this webinar. Chief judges and presiding judges have considerable power to promote change, but often do not fully use that power. This webinar will explore why chief judges and presiding judges do not step up into the power that they have and how they might harness that power to lead positive change in their courts. The presiding judge or chief judge takes on a great deal of responsibility, but also has a wonderful opportunity to create a vision for excellence and change. What is your passion? Is your passion treatment courts? Is it greater equity and inclusion? A better way to address mental illness in the criminal justice system? A case flow management system that aligns with nationally recognized best practices and improves the experience for the public? Wellness and greater job satisfaction for the court's employees? You are in the driver's seat to make positive change as a chief judge or a presiding judge. You can also identify future leaders and encourage them to accept meaningful roles in your administration so that your jurisdiction continues to experience good leadership and the work you do as the leader lives on and grows. I mentioned earlier that I was chief judge for 15 years. And although that often people often roll their eyes when I say that, I have to say that I loved every minute, even when it was difficult. It was the highlight of my career. I'd like to talk now about some aspects of the job of chief or presiding judge that create some challenges to realizing your vision, and then ask our panelists to address these challenges by offering their experience with these challenges and tell us how they crafted positive and effective solutions. If you have questions, please put them in the Q&A section. These questions will be funneled to me and I'll do my best to incorporate them into the presentation. So one of the challenges posed by being chief judge or presiding judge are institutional disincentives. In most places, chief or presiding judges are chosen by election of colleagues and for a specific short term. In some states, terms are 2 years and 2 years only. Even if your judges and staff and other judicial officers think you're doing a great job, and even if you love your job, you can't have it after that 2 years. In others, presiding judges can be elected for more than one term, but often no more than 2 terms. As a result, presiding judges may feel that they do not have time to complete a project and give up before they start. In addition, the presiding judge may feel that the next presiding judge will undo whatever that judge has done, and so don't move forward. Further, the presiding judge may not want to step on the toes of other judges and does not want to impair collegiality. There are also organizational challenges. The presiding judge may not have a good understanding of the kind of organization that he or she is leading. Court organizations are often called loosely coupled organizations. Think professors and deans or the head doctor of a group of doctors. What sets these kinds of organizations apart are that they are not typical hierarchical organizations. Such organizations, like courts, provide significant services requiring extensive and specialized knowledge and complex decision-making. The high-level members of the organization consist of highly trained professionals with extensive individual autonomy. And I want to emphasize the extensive individual autonomy. think about your roles as judicial officers and court executives in terms of that autonomy. Most decision-making is decentralized. Loosely coupled organizations exhibit a tension between institutional commitment, say, to the public benefit, and individual independence and preference for particular kinds of rules or procedures within one's own bailiwick. Learning to manage such organizations is difficult, and the effort to make decisions collaborative and carried forward can be a challenge. And then finally, some jurisdictions have a history of high acceptance of change, do it easily, especially if they'd had the advantage of a visionary leader who has led them successfully over the years. Many jurisdictions, however, resist change. Accepting that change is difficult is an important skill for a leader. Rather than fighting against change, the leader can accept that different people will accept change with differing alacrity and work with the resistance effectively. Resistance to change can derive from comfort with the known versus the fear of the unknown, the belief that change means more work, or lack of faith that the leaders will develop something better than they already have. There is also a subset of resistance of change, which can be described as passive-aggressive behavior, even if the aggressive part is not particularly aggressive. So, for example, team members may agree to make changes in operating procedure and then proceed to follow his or her own procedures nonetheless. This is especially prevalent among judges who can say something like, "You can try to make me, but you really aren't my boss." That's another expression of a loosely coupled organization. All right, so having finished my introductory remarks, I would like to start asking some questions of our panelists. And if you'd like to answer any of these questions, please, panelists, click your raise hand icon at the bottom of your screen so I can know that you want to do that. So every jurisdiction has a court executive, which is a position that is often called district administrator. What kind of relationship between the chief or presiding judge and the administrator works best to affect changes? How might this relationship support sustainable change? Okay. Judge Welty?
Well, I think the relationship is critical. It is critical to the functioning of the day-to-day court, and it's critical, especially to future projects of the court. I think that folks who are contemplating taking on a role like a presiding or a chief judge, or judges who find themselves in this role, should be comforted by the fact that it is not the expectation that you do this all by yourself, that you are working with a productive partner. We are judges, we are evidence-based, and we recognize the concepts of expertise. Most of us did not go to business school. Most of us are not trained as court administrators and do not have experience as court administrators. We know the courtroom side of the practice. We understand the culture of our court, and we, if we're doing our jobs well, have something of a finger on the pulse of where the bench is willing to go in certain areas. But we have to work hand in hand with our court administrators, because they're the ones, and I think the best example of why Ray and I, Ray doesn't let me do seminars if he's not part of the panel. That's Ray and I are that close. You know, we work together in much of what we do. Our offices are very close. If I don't talk to Ray every day, I talk to him a couple of hours of every day, because we are working together. That's the nuts and bolts of the day-to-day work. But then on sustainability, Ray was the court administrator before I became the presiding judge, and he'll be the court administrator unless he retires after I'm the presiding judge. A good portion of the sustainability of what we do has to do with the fact that he's still going to be here when I'm not making decisions with him. And therefore, the vision that we are carrying through, he will continue to be a partner with the next presiding judge to continue that vision, or at least to defend that to the next presiding judge. And the other is the importance of the close relationship is the organization you not only have to work effectively as a pair to get work done, but the organization has to see that you are close and as a pair to get work done. Because if the organization sees that I'm making some visionary decisions that Ray is not on board with and is not going to carry out on the ground, then there's nothing to it. At the same time, if Ray is trying to accomplish things and I'm sort of bad mouthing that's just court administrator stuff, then that doesn't accomplish anything. And so we really have to effectively be on the same page, and the organization has to see us on the same page for things to really move forward.
Thank you very much. Mr. Griller?
Who do you want? Oh, okay, great.
You're not responding, Mr. Griller?
Right, I should probably put my little hand down now,
Great.
which I can. Yeah, I would not only echo what Judge Welty has said, but add a few other thoughts. When we were practicing for this session a couple of days ago, I know Ray mentioned that he in his career in Pennsylvania and in Arizona has worked for I think it was nine presiding judges. I had the privilege of working for 11 different presiding judges in 2 different states and 3 different court systems. And what I would say, the relationship, the best relationship that seems to work, at least in my opinion, is one where there's a strategic partnership. And that means colleagues together in top level decision making. The presiding judge has the organizational power, but lacks the operational knowledge. The CEO or the court administrator has the knowledge, but lacks the power. So these this two-person team merges those relationships through a number of different skills. One is clear roles and responsibilities, where you sit down with each other and say, okay, here's what I do, and here's what you're going to be doing, and here's all sorts of things that we'll do together. Frequent access and communication. One of the presiding judges I worked for years ago, when I'd walk into his office in the morning, he would say to me, "Gordy, what do you know that I should know?" Well, there's a lot of things I know that, and I had to choose very carefully what he really needed to know, because there were lots of things that I could take care of on my own, knowing where his mind was on those things. So mutual trust, that's another issue. Trust is not only competency, but it means benevolence. It means you put the interests of somebody else or the interests of the organization ahead of your own personal interests. And lastly, when it comes to basic approaches, it's a shared vision and strategy. Judge Balin's right. 2 years, maybe 4 years, maybe 6 years is not enough to accomplish some of the major issues and major changes that need to take place. So the court administrator is not only the institutional memory, but he's the continuity, or she's the continuity that can carry it on with a new presiding judge. And so one of the questions I get when I mention this notion of strategic partnership is, well, what do you mean? What are the definitions aside from the 4 sort of approaches that I mentioned? Well, one of them, from the court administrator's standpoint, is empathy. The ability of the court administrator, the CEO, to understand the feelings and the issues, perspectives, and motives of a chief judge. And how can you identify some of that? Is the court administrator involved in meetings with the judicial leaders? effective effective leaders, is he an effective leader of the non-judicial staff? In other words, does he empower his people and delegate appropriate responsibilities? Does he leave a legacy of competence when he or she is gone? It's not true that the more time a court administrator spends with a presiding judge, the more the presiding judge will turn to the court administrator or the CEO for insights and counsel. Face time does not equate to strategic advice. The issues really are, how do you develop not only that partnership, but how do you develop on a strategic basis? And that sometimes is very, very difficult in some courts. But
Thank you.
anyhow, I rest my case, as they say in our business.
Okay, thanks. Mr. Billett?
Yeah, just briefly, I wanted to, this webinar is about the proper use of power and how presiding judges can use that in an appropriate way. And I think sometimes in the relationship we're talking about here, that perhaps a presiding judge may feel like he or she is giving away some of that power in that productive pair relationship, and maybe seen by their colleagues as, well, wait a minute, what are you doing? You're the presiding judge. You have the total authority and power here. In my career, it's just been just the opposite. When there is that relationship between the presiding judge and the administrator, I think it strengthens the PJ's authority and reputation and power within the branch itself. And I think sometimes we feel like judges feel like, that's mine. We need to keep that here. So I think it actually in practice works the opposite. So I just wanted to make that point. And I would also say for those judges who are just became presiding or chief judges and those who will be coming, relationships just don't happen. They take work. And, Judge Welty and I just didn't walk in one day and say, oh, we're a perfectly productive pair. We weren't. He and I did not have a lot of opportunity to work in the past together, but you work at it. And the last thing I'll say from an administrator standpoint, and I enjoy this with my current presiding judge, when we have our one-on-one once a week for an hour, that is a safe space. That is a space where he can say anything, I can say anything, and it stays in that room. And so we've developed that ability together to understand each other, and we don't meet as much as we used to. We really don't have to, because we now have an understanding of how it happens, but that takes some time. It doesn't happen overnight. So thank you.
I would just add before I send this over to Patty Tobias, is that I had the great fortune of having a wonderful court executive who was highly skilled, highly educated. And what we were for each other was not only a confidential pair that could discuss anything, but we were also the support in other ways. So if something was going very, very bad and it felt emotionally draining, we always knew that we could talk to each other and make each other feel better. When you're at the top of an organization, who was I going to talk to? I wasn't typically going to talk to my staff, or I wasn't typically going to talk to other people in the building about my own fears about something not working as well as I hoped that it would, or any of those things that you don't want to share with other people. And she knew that she could do the same with me. I also think that administrators who've been around for a long time, of course, provide institutional memory and sustainability. But for those organizations or those judicial districts that get new administrators, often that's the sort of new blood concept where ideas come into your district that are new and fresh and more evidence-based, and it can liven a district and really help the chief or presiding judge move forward. Patty?
So I just wanted to emphasize all the points that the other panelists have made about the importance of that relationship. And I wanted to point out the roles, principles, roles, and responsibilities in the monograph that was produced by NAPCO, titled Presiding Judge and Court Executive Officer, Trial Court Governance and Leadership, Principles, Roles, and Responsibilities. And I just wanted for those judges who might not yet be a presiding judge, but also those presiding judges and court executives who are in place right now, perhaps this could be an opportunity for you to take a look at that monograph and really reflect upon what are your leadership goals and skills, what are your insights to how you're operating as a productive pair. Oftentimes we get so busy and so focused on what we're trying to accomplish that we don't have the time or take the time to reflect upon the relationship, reflect upon how we are demonstrating the sort of leadership that is needed in order to change and improve our courts and our court administration. And I really like one of the guide principles. And if I could just read it to you for a second. On page 4 of the guide, presiding judges and court executives are colleagues in a common purpose to guide, motivate, develop, and energize those in the trial court, those in the justice system, government, and the community at large to continuously improve the administration of justice. In doing so, they are expected to respect each other's abilities in working toward those goals. I just really like that as a guiding statement for the productive pair relationship between all of our presiding judges and all of our court administrators.
Thank you so much. That's a great way to end this question.
Judge Billis, I wanted to just add something here.
Okay.
And that is, because from experience coming in as presiding judge in 2020, I had all these visions and goals and policy changes that I wanted to make. And, I thought, okay, how am I going to do that? Right. And so I kept thinking, okay, my first meeting, I'm going to assign who my presiding judges are. I'm going to make these appointments to the committees. I'm going to do all of these things. And when you look at the structure here in Hennepin County, there's 63 judges, there's about 14 referees, but there's 550 employees. So yeah, I could get to the judges, but how was I going to get to those 550 employees to buy into my vision, buy into my goals or policy changes? How was I going to get that support? So I quickly realized that my success was tied to our court administrator. I could not succeed in any of the things that I wanted to do if her and I did not have a good relationship. So I needed to make sure that all of those things that I thought were important were also important to her. I had to make sure that every direction I wanted our bench to go, that she agreed with that, because yeah, I might have the ear or the audience of the judges, and I might be able to send an email out to 550 employees, but I needed her to be able to also deliver that message to her deputies, and then down to the senior managers, and then down to the lead workers, and then down to the people who are actually doing the line work. So that relationship is so important because of the structure that we have in being able to actually accomplish the things that I wanted to accomplish. So the relationship is so important to what you want to do.
All really good points. And when I was working with my district administrator, once we figured out what we thought we ought to do, whether we needed to convene a committee or not, but made a decision ultimately, there was always a discussion at the end. What part of this is yours and what part of this is mine? And there were usually quite distinct skill sets and audiences that were important for each of us. Okay. Okay. The next question really has been partially answered because it has to do with sustainability. I was talking earlier in my introduction about short terms, and it sounds like in most parts of the country, you have 2, 4, or 6 years to be the presiding judge or the chief judge. And if you feel reluctant to get started on a project because you think you can't finish it, one of the answers to that we've just talked about, which is that your administrator is probably going to be there before you and after you. And if you are working together to a common goal, then that person is likely to carry that over to the new presiding or chief judge. But I'm interested in whether any of you have other ideas about how you can make your changes sustainable over time.
I don't mind taking this one first. You know, one of the way that we're structured is that as the chief judge, I get to appoint who's going to be the presiding judge of all 5 of our divisions. That's criminal, family, civil, probate, mental health, and juvenile. And so each presiding judge has an assistant presiding judge. And the idea is that at some point, whether it's during my tenure or after, hopefully those assistants will take the presiding judge position at some point. So when you have buy-in from all your presiding judges about your vision, and also I should say I have an assistant chief judge. So with all the decisions that we make collaboratively, those decisions also include the presiding judges and also court administration. So as long as people have buy-in for what the goal is or vision, that seems to be able to carry on. So just like the chief judge before me, I was the assistant chief judge, and some of the things that she had in place, we continued on. And so I think that's been very good for us here in Hennepin County.
So much. Judge Welty?
I agree with everything that Judge Barnett, and we have the advantage, given our size, of having a management structure that also provides me with an opportunity to put people in those positions. But what I wanted to say beyond that was, I think if you're a judge out there and you have a 6-year term and you think this question doesn't apply to you, then you're wrong. I mean, we're working on significant capital improvement projects. We're working on significant capital plans, which with our county or something, we're talking about 10-year projects. We're talking about substantial technology projects that are never going to be 6-year projects, and the development of them that moving forward is critical. I think you have to let go of a lot of your ego on this stuff. This is not Judge Welty's virtual hearing plan. This is not Judge Welty's plan for how it is that we will build out the Southwest Valley. This is the court's plan. This is the branch's plan for moving forward. And beyond simply your formal leadership judges, you can form committees and pull people both from administration and from within your bench. And spoiler alert, some of the younger people, the folks who aren't going to retire at the same time you're going to retire, and get them involved in those committees so that the committee is the one that decided what the 10-year plan was. And there are significant elements of that committee that are going to be present for the next presiding judge and the next presiding judge after that. So, let go of some ego, put some other people in it. And when you let go of your ego, I think it's also important that we have to acknowledge, I have to look at what is sustainable and not simply at what my vision is. And I have to be willing to compromise with these committees with the understanding that I guess I could put my foot down and build what I wanted to build, but I'm not sure that's going to last. And if I compromise and build what the committee wants to build, then I have more confidence that it's going to survive.
From a county that has 330,000 people, so it's medium size. It's not really small, but it's not these mega counties. I didn't have an assistant chief judge, or I had a presiding judge of our limited jurisdiction court, and that's it. So if you don't have institutional positions such as the two prior speakers have been discussing, you can still create an executive team. You can still say to yourself, among my 14, 19, 5, 7 judges, who's showing passion for court organization, who really has a passion for serving the public, for changing our system, for example, or a system from a judge-focused system to a public-facing and public connected kind of system. Who out in the community needs to be part of the judicial process of decision-making in order to do the best job for the public, and then get those people onto an executive team. They don't have to necessarily be the next chief judge. They don't have to be have a particular title, but if you've got a bunch of really interested, thoughtful, smart people helping you with projects, they carry on. Patty, you wanted to say something?
Yeah, I was just going to add to all of your wonderful remarks that the leadership of the presiding judge, again, whether it's a 2-year, 4-year, 6-year term, and the relationship with the court administrator goes also hand in hand with the governance principles and a well-defined governance system. What decisions can the presiding judge and the court administrator make? What decisions can the executive committee make? What decisions should fall to the court and bank? And having a well-defined governance system fully supports the presiding judge and court administrator and their efforts to lead those changes. So I just wanted to add that one point, and going back to the monograph that NAPCO has produced, governance principles are number one. You have to have a well-defined governance system to help to support the leadership of the presiding judge and court administrator.
Very important point, thanks. I think there are a lot of jurisdictions that I've seen as I've traveled around being a consultant for the National Center, who have meetings periodically. Some don't have any meetings at all, but some have meetings periodically, once a month, every other week, whatever it is. But there's no clear understanding of what the agenda should be, what the result of the meeting should be, and a way to carry forward decisions that are made. There sometimes isn't prep work by other people who bring their research, their study, their recommendations to the group. And so they're good because all the judges get together and they talk and they keep their relationships going and they make some decisions. But because there's no governance structure, they're not making as big a difference as they could in terms of moving projects forward. Absolutely. Anyone else want to make a comment? Okay. So I mentioned also in my introduction that some chief and presiding judges are reluctant to lead change for additional reasons besides the fear of lack of sustainability and so forth. I hear over and over that judges value collegiality above all else. I value collegiality tremendously because I think that in loosely coupled organizations, you have to have judges and other judicial officers who are willing to give up some of their autonomy, which they automatically have, for the greater good of the district, and trying to create an infrastructure in which judges say, yes, I will do it this way because it's better for the public. It's better really for us in the long run because we're interacting in a way that's supportive for each other. You know, that's the ideal, but I do see places where judges are so focused on getting along that they can't move ahead to make decisions. They don't want to rock the boat. They think that if they make a suggestion that's not popular with one or more judges, then they'll be stepping on toes, that they'll annoy their colleagues, whatever it happens to be. And also, although this is somewhat conversely, a chief or presiding judge may be willing to lead change, but meet with opposition from judicial officers who assert that autonomy. And one has to employ strategies to bring people on board who really deeply believe that they should have autonomy and make their own decisions within their own departments or divisions. So let me just ask the question, the first part of that question, which is, how do any of you or all of you deal with the issue of judges valuing collegiality to the point that they are not willing to move ahead and make decisions for fear that it's going to annoy their colleagues or step on people's toes? Thoughts?
I'll take a
Okay.
stab at this. Look, collegiality has value because judicial independence is paramount, and you absolutely cannot step on judicial independence. But it depends upon your court culture. We talk a lot about judicial independence about in the four corners of the courtroom and in the rulings you make at your desk. That's different than judicial independence about, you know, deciding when you're going to come and go and some of the more structural aspects of the court. I think first and foremost, you're, as a new leader coming in or someone who's desiring to be a leader, you have to understand the culture that you're walking into. Judicial leadership should be about making your court system better. Now, I completely recognize that in some court systems, judicial leadership is about somebody's responsible for making sure the lights get on every day. You're responsible for making sure the lights get on every day, but that's it. The rest of us are doing everything else. I think that's difficult, and I think that's a culture you need to change, because if the culture of your court is that you're just responsible for turning the lights on, then you need to figure out how to change that culture into some entity in that system has to be responsible for making that system better. And that's a difficult culture. Now, if your culture is that that's what that leadership is, and you're just hesitant to do it, I think you have to remember, first and foremost, it's your job. You are there to improve your court system. You are not there to be popular and to have all of your days go easy. I think the second thing you need to do is you need to make sure what authority you actually have and what projects you need to move forward with your own persuasive abilities. And I think if you don't know what your power is, your judges probably do. And if you overstep that, they will remind you where your boundaries are, and you lose a lot of credibility if you try and tell people something that you're really not allowed to tell them. Now, facilities, I mean, in many court systems, and certainly in this court system, you know, facilities are the responsibility of the presiding judge, the chief judge. Budgets are the responsibility of the presiding judge, the chief judge. Court tools, court resources are the responsibility of the presiding judge and the chief judge. And so when you move projects like that forward, you're clearly in your space. When you start to tell people how to run their calendars, you have to be pretty careful about mandating stuff. And my suggestion will always be, where you're on persuasive authority, you can establish best practices. And if they're truly best practices, and if they truly work, then those who buy into them will buy into them and demonstrate that they work. And those who are hesitant will, over time, either retire or see that they work and adopt them. But you don't get very far making people do something that they don't actually have to do if they don't want to do it. And so, you have to be transparent about your decision-making all the way down the line. You have to treat your bench, I think, the same way you treat the public. Procedural fairness matters as much to your bench as it matters to the public. Why are you making the decision you are making? And if they disagree with you, they may disagree with you, but they understand how you got where you got. And most of them don't want this job. So they're just appreciative that somebody thought enough to make a decision and explain it. And I think you get a long way with that kind of transparency.
Okay. Other thoughts?
I totally agree with you on that. I also think that one of the things that you touched on is just that piece of governance where you have rules. We have bylaws here. We have probably a policy for everything you could imagine. And so I say that to say that, I've had this issue come up before. And, as a judge, it's very interesting. We make decisions in the courtroom every day where one party is usually happy and the other party is disappointed. And then it comes to our colleagues and sometimes we want to please them. But as a leader, I just think that, like Judge Welty said, you're here to make the court better. And so if your decision making and any of the things that go into that are transparent, I think people will respect that, even if they disagree with you. I know if Chief Judge, we have 62 other judges here, and when they disagree with me, they let me know. But I'm very transparent on how I got to that decision. And I make sure that my door is open for them to discuss those things, whether they're in a meeting or privately. I make sure that they're able to be anonymous and get it through the assistant chief judge, however that gets to me. But I think that transparency piece is the most important as you go along as the chief judge or presiding judge.
You're muted, Judge. I think you said my name, so I'm going to go ahead.
I did, sorry.
Thanks. And I think, absent what we just went through for the last 2 years, the pandemic operations, where we were in a different management mode, where you had to make decisions now and for today and keep going. We have a very deep and consistent approach to any new programs that we put in place here in Maricopa. The judge often appoints ad hoc committees or uses our Judicial Executive Committee to vet ideas, thoughts. Hey, this is what we're looking at. Uses the monthly bench meeting to inform the bench on where we're going. Puts me in a position then to make sure this side of the house, the administrative side of the house, understands what's going on and allows us to provide substantive input to any of those decisions that happen. So there are very few, you can correct me if I'm wrong, Judge Welty, there are very few decisions that are implemented or changes that are made that don't have a significant involvement of a portion of the bench or a portion of our administrative team. So and again, that's absent what we did in COVID because there was no way to do that. But so that's one of the ways that you can avoid a lot of those pitfalls that happen if you and another colleague have worked on this project, this plan, and all of a sudden it's ready to go and you announce it. That often creates some animosity amongst people that, why weren't we informed of this? Even though it might be the greatest idea, you're naturally going to get pushback on some of those ideas. So.
Right.
But even, and let me just quickly follow up on what Ray said, because I think even in COVID was a very good example of, you needed executive decision-making on a day by, sometimes you elaborately put in place a plan for Tuesday and by Wednesday, it was a wholly different plan. And the expectation was the whole reason there is a presiding judge is 165 people can't make that decision together. Someone has to make that decision and decide it. But that doesn't take transparency off the table. It really doesn't. It's still necessary to say, this is what we did, and this is the information that we had in front of it, and this is why we did it. And so I don't think you get to use emergency to say, because I decided. I just don't think you get to do that. And if you do that, you're just going to find yourself with other sorts of resistance issues down the road. I'm sorry.
I've always felt that there's always going to be a few people who don't want to change at all, or who really want to express their autonomy absolutely. And although I didn't have that problem a lot, my goal was to develop a leadership style that was very inclusive, broad-based, collaborative, and include people from the very beginning. This goes back to that governance mechanisms, having task forces, providing people that you think can show leadership potential, providing them with roles and providing opportunities to participate in the decision-making process. It increases your legitimacy among a larger number of people and increases the trust that people have in you. And ideally, as was mentioned earlier, you have some very experienced people, some medium experienced people, and some newer people who may surprise you with great ideas, even though they don't have much experience, and you're also grooming leaders for the future. And Patty, you wanted to add something.
Yeah, I just wanted to add, this has been during the pandemic. We've seen so much leadership and so much innovation by the courts across the nation. But we've also seen many judges and many court executives and court staffs really experience high levels of stress and anxiety, grief, depression. And so sometimes resistance, sometimes that exerting autonomy could be a symptom of a lack of mental health and well-being. And so I just want to think about and have our presiding judges and the court administrators think about the mental health and well-being of the judges across the nation or in their jurisdiction, and the well-being of their court staff. I don't think we've paid enough attention to that as we think about the sort of systemic changes that are necessary in all of our jurisdictions.
Yeah, thank you for that comment. I think that people have been under a great deal of strain, and all of you have probably had the whipsaw of thinking you were opening and then not opening and then opening more and then maybe having to close again, and it's mass today and no mass tomorrow, and it's really hard on lots of people.
Judge Bellis,
Go ahead.
I have to say this because I've said this before because I'm so proud of our staff here. One of the things that I would say is that prior to the pandemic, we were doing about less than 50 cases a month. So 2020 May, we were doing less than 50 remote cases a month. Now we're up to anywhere between 3,000 and 4,000 remote hearings a month. Now, I say that to say, if I would have, prior to the pandemic, if I would have said to our district, we're going to move to remote hearings, I would not be the chief judge of Hennepin County. But what I want to say about that movement and leadership and all those other things is that at a time of crisis, our judges and our staff got together and really look, and I'm talking about all over the country, not just Hennepin County, the courts all over the country have gotten together for one purpose, and that was the betterment of the court. How could we get the court's business done in a way that was safe and efficient for those court users, whether they were coming into the courthouse or by Zoom? And staff and judges did that all over the country, which is so inspiring and encouraging, because at a time of crisis, we were able to do that. And so as we talk about the pandemic, I just really want to say that about what we did as a court system all over the United States.
That's great. It also taught jurisdictions a lot of things about when is remote good, and maybe we want to do it continually, and when is it not so great. And because
Right.
It's really about the relationships in the courtroom and about people being present with each other. But also help some jurisdictions kind of identify cracks in their infrastructure such that they weren't as nimble perhaps and as able to meet the crisis. And how can we do a better job of creating a strong decision-making, inclusive way of moving forward.
And learning from each other, you know, figuring, I mean, we had the Derek Chauvin trial in the middle of the pandemic. And so we really had to reach out to other jurisdictions, just saying, what are you doing? And people were reaching out to us as well. But it was that we're all trying to get through at least what we thought was going to be a short pandemic. But just that we're working together just for the betterment of the courts, you know, and not for individual people. So.
And Judge Bowen, I would say beyond COVID, beyond the pandemic, if you're not using that as a teachable moment in your court system, you're crazy.
Yep.
That is a moment of this bench is resistant to change. Look at what you accomplished in the last 2 years. Look at the benefits that we derive from that. And then it doesn't have to be remote operations. It can be any other operation to say, look, we have these folks in an open-minded moment when they turn themselves on their heads and they saw success. And if you're not using that as a teachable moment to change your culture or to change programs, you're really missing something. And I certainly get, we're all exhausted. I'm not suggesting you do it tomorrow. Not suggesting you do it tomorrow, but when you do it, you've got a bunch of people who have seen this happen, and you have to seize upon that.
Right. Well, and people have experimented too. So, you know, did you have arraignments where the district attorney and the defense counsel were not present and it was only for setting bond, but then they decided to come because they could move the cases along faster and get them out of the system and not clog them, and then it worked really well. And so let's keep doing that after we can all do it. I mean, that's a small example, but it's a good opportunity for kind of pilot projects or experimenting as well. Okay, well, I also think that with regard to the change process, that leadership is critical. You know, in my work in my state and also around the country, strong leaders make good courts, especially if they're good leaders in the sense that we are talking about good alliances with their court executive, if they have assistant or associate chiefs or presiding judge is working together for a common vision. Another way that I found very useful when I had it in my mind that there was a problem to be solved or a system that needed changing or a vision that I had and didn't know whether people would be with me, is that I just convened a whole lot of people to talk about why I had gotten to a point of thinking that something needed to be better. You know, our data was not showing that we were moving cases in a prompt way, or our bond system was penalizing poor people and keeping them in jail unnecessarily, whatever it happened to be. I would start by saying, this is what I think is a problem. What do you think? Do you think this is a problem? And trying to identify a problem, and then collaboratively working on a vision to solve the problem, and then, you know, get going on it. The other thing that I think is really important for positive change is having people feel like there is movement in the process that everybody agreed should occur. So I've used this metaphor probably too many times, but if I had buy-in with the people that needed to buy in, and I felt like we had a vision for how to move forward and where we wanted to get, I would figure out when I needed to pull the train into the final depot, and then move backwards in terms of what needed to be done at various times in order to get there on time. And then convening subgroups and groups and making sure that we were always engaged in next steps, that people didn't forget what they were supposed to do before we had our next meeting and so forth. So there was an energy in moving forward to a common goal. And that tends to make people feel like they're almost enjoying the process of getting to the common goal. And I also found that once I had, you know, let's say convened a task force on mental illness and addiction in the criminal justice system, which was one of my task forces, that when we identified a problem, came up with a way to solve it, worked together collaboratively and also relatively quickly and actually solve the problem, that generated a passion for solving other problems. Once you know that the infrastructure of the people around the table and their creativity, their good ideas are actually making a difference, then they want to do more of it. And I think that that's another thing that that being chief or presiding judge gives you an incredible opportunity to accomplish. Okay, were there any other comments that any of you wanted to make on, not specifically an answer to my questions? We did talk to some degree about oppositions from judicial officers who just assert their autonomy and don't want to hear otherwise, but I think we covered that because it's really the same answer to not wanting to step on people's toes. Okay, I've got some hands up. So Gordy, you haven't spoken in a while.
Yeah, thanks, Judge. One of the things I was going to mention, I know we're getting close to the end of the 75-minute webinar. And one of the things that we indicated early on in presenting this is that we want to leave the audience with some takeaways. In other words, some things that they can actually follow. There are a number of things, obviously, that have been mentioned throughout the hour or so, but I'd like to just draw the audience's attention to 4 items that I feel might be helpful. And this is the result of, and I hate to even say this, but of about 50 years in the business. And, you know, I mean, my guess is a lot of you might have been in grade school when I started with the courts, but I was always looking for things that made sense and that might have been confirmed, say, for instance, by brighter minds than mine, as leadership experts or organization development experts. And I realized that the court system, like hospitals and like universities and so on, is loosely coupled and so difficult to change. But let me give you four approaches to dealing with change in organizations that you might, the audience might want to consider. And they're all books by basically professors from Harvard. Now, I don't know why Harvard surfaced as the whole thing, but I felt that they were really quite effective. One is a book that many judges find interesting, especially after their term as judges and they go into mediation work or arbitration work. It's a book that started the Harvard Negotiation Project, and many of you probably have heard about it. It's called Getting to Yes, done by Richard Fisher and William Uray. And it has 4 basic principles on how to deal with difficulties when people don't agree. And so I would recommend that. The second would be Professor John Cotter's book on major change. Cotter is also a leadership and organization change expert. And he sets out 8 steps that he recommends that you follow in sequence when trying to implement sustainable change. As an example, the first step is establish a sense of urgency, exactly what Judge Balin said earlier when she said, this is a problem that I think we have. What do you think? So establishing, why is this problem more important than any other problems that the court as an institution might face? And it goes through various steps. And at the end of the trail, at the 8th step, it's a way to anchor the change into the culture of the court. And what does that mean? That means sustainability. The third document or book that I would recommend to the audience is a book called Leadership on the Line. It's done by Harvard professors Ronald Heifetz and Marty Linsky. They've had a lot of experience in government. Neither one is a lawyer. Neither one is has been a judge. But their premise, I think, is very useful to us. The premise is that there are two types of problems. One type is called technical problems. They're high ground problems. They have ready-made solutions. It's the stuff that Judge Balin and I and Patty Tobias deal with when we talk about reducing case delay, trial court delay. This is the way you need to operate a pretrial. This is the way that you need to deal with your motions and so on. The other problem that Heifetz and Linsky says that you've got to deal with is much more difficult. They call it a swamp issue. It's an adaptive problem where you may understand the problem, but you've got to invent the solution. In other words, you've got to change the attitudes, values, and beliefs of the people with the problem. And we talked about that just a little while ago when we talked about crisis and how to deal with the pandemic. The attitudes, values, and beliefs of judges and court staff changed significantly as a result of that crisis. And so we're doing things differently now that we'll be doing for the rest of our careers anyhow. And the last book that I would recommend to you, it's kind of an interesting book. It's called Immunity to Change. It's written by Robert Keegan and Lisa Leahy. They're also affiliated with Harvard. And it analyzes the resistance to best practices approach from a human psychology approach. And so they focus on why you're not doing the kinds of things that you should be doing. And what are some of the hidden assumptions? What are the reasons why you're not doing a better job as a court? And how can you achieve those? And it's kind of a guide, sort of diagnostic. It's sort of medical version. So I will put these documents on the website. Should anybody in the audience be interested in taking a look at that, I think it gives you a framework in how to understand organization dynamics and how to understand leadership and resistance to change, not only in loosely coupled organizations, but in any type of organization. I rest my case.
So I do have one question from the group. The question is, do you recommend the chief judge has staff and/or staff assistants independent of the judicial administrator's office?
Well, we're just organized that way. The judicial staff for the judges are our own staff. So it's not from our court administrator. So my two clerks, one is administrative clerk, one's a law clerk, are my employees.
Right, but you don't, was that the meaning of the question? Yeah. I think that all of the judges have their own staffs. I'm wondering if the question has to do whether you have a sort of chief judge staff that's just for you because you're chief judge, that's different from the judicial administrator's office. Do any of you have that? And if so, do you recommend that?
I would recommend that the presiding judge or chief judge have an independent staff. I think there is some value to what each entity brings to the table, and if you're both dependent upon exactly the same staff, you may not gain as much of that, the value of the independent. So we have, Ray's got separate staff than I have. They work very, very closely together. They work on the same floor of the building, but we each have sort of our own folks, and I think that's beneficial, and I would recommend that.
I think it also depends on the size of your court. mean, in my court, I would never have had the opportunity to have, I mean, I had my own judicial assistant and my own law clerk and my own court reporter, but I didn't have any staff per se that was assigned to me simply because I was the chief judge. And I don't think that anybody in my state has that. So it's a different sort of structure. Anybody else? Okay, well, we have come to the end of our time. And I want to thank all of you out there so much for participating today, for watching today. And we certainly hope that we have helped you learn about some useful tools related to stepping up into the full leadership role that you have as court administrators and presiding and chief judges, as well as those of you who are listening who are assistants or associates into those positions, or those of you who aspire to be in those positions. We've certainly talked a lot about the challenges involved in those leadership roles, but I want to leave you with our enthusiasm for the jobs that we have now or have had in the past. I just felt that I had an incredible opportunity to make changes that really were necessary to be done, to build a new courthouse. I was able to do what I called throwing open the doors of the courthouse, so that I included mental health services and addiction services and Department of Housing and Human Services, and any organization, housing organizations, any organizations in the community that could help me develop programs that would help families and individuals rehabilitate so that they could re-enter their communities as contributing members to their communities. That was one of the things that I focused on. But you have the opportunity to realize your passions, to get people involved in projects, to encourage connection, collaborative interaction with people, and to raise your jurisdiction to higher levels. And it can be difficult on many days, but also exhilarating when it works. So thanks very much for joining us today.